So this defence is called insanity. Okay, so this defence is related to another defence called automatism. So a few notes to write at the top of the handout. There are two forms of automatism. So both defences are called automatism. Now, just to give you some sort of background information and some of this to note at the top. Both insanity and automatism deal with a defendant who has suffered a malfunctioning of the mind. So it could be some type of seizure, a blackout. That's the common issue with both defendants, insanity and automatism. So both are types of automatism, both deal with a malfunctioning of the mind. So, as they are both automatism, they both have two different names. So this is where it gets a little bit confusing, but stick with it. Insanity, which is this handout, has a second name. So insanity dash, also known as insane automatism. The second handout, automatism, also has a second name, dash, non-insane automatism. So when you read the textbooks, you can see that different authors and different academics and teachers use different names. Some use the insanity automatism labels, which is what I do, or others will talk about insane automatism and non-insane. So I would prefer to use insanity as this handout and automatism as the second handout. And that's what I've done for years, and students have done fine in the exam. Just makes it clear that there's two separate defences. Insanity, this handout, automatism, the second handout, just so you acknowledge that both are related to automatism. So basically you've got a bunch of defendants who suffer a malfunctioning of the mind, and some are placed under insanity, some are dealt with under automatism. So basically a defendant should technically fit in one or the other. In short, and this is a little simplistic, but it works for now. In short, where the malfunctioning of the mind has come from an internal cause, that tends to be dealt with under this handout, insanity. Alternatively, where the malfunctioning of the mind was triggered by an external cause, then that tends to be dealt with by the second handout, which is automatism. Then, just to confuse matters further, there are several conditions which are covered by both, and that's the same section on both handouts. I call that section DDS: diabetes, dissociation, sleepwalking. So at the middle of this handout, it's the exact middle on the automatism handout, it cites those three conditions, and those are three conditions that can be both insanity and or automatism. But it's very important that a defendant knows which defence is their relevant defence, because obviously there's a different label, the result of a successful plea is different, the burden of proof is different. So if you go down either route, the process is very different and the result is different. So really, as with many areas of law, Parliament do need to reform. Parliament have never looked at insanity or automatism, and so the judges have developed it, but it's very medical. So obviously that's outside their area of expertise, and that's why a lot of this is very uncertain. Okay, so now we've done the intro material, now let's concentrate on going through the defence of insanity. So, in terms of insanity, it sounds like one of those really interesting topics that students really look forward to studying, but actually a lot of it is medical, and some of the cases are not quite what you would imagine. And in fact, insanity is pleaded very, very few number of times per year. And there are lots of reasons for that, so it's very rare to see it in court at all. Couple of reasons just next to the first paragraph, or below the first paragraph. The defence is described as archaic. So this comes from 1843. So the defence is archaic, significantly out of date. Also, as I touched above, none of it is medical, or none of it is in line with medical thinking, which is a huge problem. Another reason is the label. No defendant, whatever their mental condition, would want to be labelled insane. And when you are successful with insanity, you get the label of insanity for the rest of your life. Nobody would want that label for the rest of their dying days. Also, another reason, a final reason, in particular for the offence of murder. If you plead guilty to murder, you might do 13, 14, sometimes even less in prison in number of years. Whereas if you plead insanity for murder, you will never, ever, ever be released. So again, that's a defendant who isn't likely to raise insanity. So there's loads of reasons why you don't see it at all, very often, in the courts. So insanity is governed by the M'Naghten rules, which provide a defence to those who commit crime while suffering from a malfunctioning of the mind. The defendant must suffer from a defect of reason, from a disease of the mind, which means that D does not understand the nature and quality of his act, or if he does, or she does, D did not know what he or she was doing was wrong. So insanity has a number of key elements, and this is the structure of the handout. Got a very small section about the presumption of sanity. Defect of reason is the first element to be established for the defence. Number 2, second element, disease of mind. And then part 3 is kind of an either or. D did not understand the nature and quality of his actions, or if he did not know he was doing a wrongful act. And if all that is established, so the defect, disease of mind, and part 3, then that results in the special verdict. So the special verdict is when insanity succeeds. So just to sort of paraphrase this at the side, so we know in terms of application, section B and section C, you're looking to establish 3 different things. Right hand side, number 1, DOR, which is defect of reason. Number 2, DOM, disease of mind. And number 3, N and Q, nature and quality, wrong. So what we're trying to do there is just paraphrase it down to the key elements you'll apply if it's section B or section C. So part 1, DOR, part 2, DOM, part 3, nature and quality, wrong. And that's basically the structure of the handout. Right, just before we move on then into insanity or insane automatism, as we mentioned above, the problem with this 3-part test is a lot of it is non-medical, and actually a lot of the tests above, how they've been described and defined by the courts, prevent the most dangerous people in society from gaining a successful plea. So actually everything about this defence is actually not gaining the right result, i.e. making sure really dangerous people are, given treatment or incarcerated into a mental institute. But we'll get that as we go through, and we'll see the issues that apply. So insanity, also known as insane automatism, is a general defence, so it means it covers all crime. And it was formulated in 1843 and is governed still today by the M'Naghten rules. You'll note there that M'Naghten is an unusual word, and the spelling of it's a little unusual, but because it governs the whole of the defence and you'll be using that term a lot, you really do need to make sure that it is spelt correctly. Okay, so the McNaughton case. So the defendant was suffering from an extreme paranoid condition and an insane delusion that the Prime Minister at the time, Sir Robert Peel, held a personal grudge against him, just him, that every Conservative policy that was raised and put forward was just personally against him. McNaughton believed he was being persecuted by the Conservative government at the time, and as a result he attempted to kill the Prime Minister, but instead ended up killing his secretary, Sir Edmund Drummond. So, Dee was found not guilty of murder due to his mental state and was committed to Broadmoor until he died, and that was 20 years later. So that seems like justice and fair enough that he's in prison being such a dangerous character, but this case led to a significant amount of uproar, and the reason being is the uproar is that the fact he was sent to Broadmoor, which is a secure mental institution, had nothing to do with the verdict of the court. Hence there was public outcry that the court should be dealing with mentally abnormal offenders. So as a result, due to the public outcry, the House of Lords were asked to clarify a defence of insanity, which led to the creation of the McNaughton rules. So the 14 law lords in McNaughton defined the defence of insanity. So that's where the defence really started and where it was defined, and most of it has not changed since. So you can clearly see from the year of the case, 1843, that this is something that is in desperate need for reform. And the good way to describe it is it's archaic in nature, i.e. very outdated. Okay, so the rules then. So the rules of establishing insanity. Juries ought to be told that in every single case, every man or woman is presumed to be sane. Even if they've got several different disorders, it doesn't matter. Every person who goes into court is presumed to be sane. In order to establish the defence, the defendant must establish that at the time of the crime he was suffering from a defect of reason, from a disease of the mind, meaning he did not know the nature and quality of his actions, or if he did, then he did not know what he was doing was wrong. Okay, so a few lines on the presumption of sanity. Everyone who comes before the court is presumed to be sane. If the defendant raises the defence of insanity, then he has to prove it on the balance of probabilities. This departs from the normal rule that the prosecution have to prove every aspect of a case to the satisfaction of the jury. So this is an exception to the standard rule that it's the duty and the job of the prosecution to prove or disprove any offence or defence. That's what they're paid to do. But you'll remember from diminished responsibility, that was exceptional as well, in that it was the defendant that must establish. And this is the second exception. Everything else is prosecution. So, however, if the prosecution raise insanity, and they have a duty to do so if there is evidence raised within a trial regarding Dee's mental capacity, and if they think that clearly insanity would be a relevant defence. In order to protect society against dangerous individuals, they have a duty to raise that defence. So the second rule is if the prosecution raise it, then they have to prove it. But normally it's the defendant. So just a note at the bottom of the handout there, the burden of proof is D, which is unfair. Secondly, it is inconsistent with automatism. And remember, these are both types of automatism dealing with the same or similar type of defendant. So it does seem right that one is the prosecution and this defence is the defendant. And as we noted on the DR handout, where D has to prove his own defence, that potentially breaches Article 6 of the ECHR. That everybody has a right to a fair trial. And clearly, if this defendant with mental issues is having to prove and establish his own defence, that could compromise his right to a fair trial. Okay, part 1 of the defence is the defect of reason. So this has to be there. All three parts have to be there for a successful plea of insanity. So the defect of reason, D's powers of reasoning must have been impaired. If D was capable of reasoning, but just merely failed to use his powers, this will not be a defect of reason. The defect of reason must be more than absent-mindedness, forgetfulness, or confusion. So, in short, it's got to be a deprivation of powers rather than just a failure to use. So, the one case which defined the defect of reason is the case of R.V. Clark. So, the defendant, May Clark, went into a supermarket and placed several items into her bag, including a jar of mincemeat. She left the store without paying for some of the items and was charged with theft. Now, the defendant claimed that she lacked any mens rea for theft because she had no recollection of placing the items in her bag, as she was suffering from absent-mindedness caused by diabetes and depression. Indeed, she argued that neither her nor her husband ate mincemeat, and therefore it could not be theft. So she was a diabetic, so she was feeling a bit under the weather, hence the absent-mindedness, plus the depression that she couldn't remember putting these items into the bag. So the trial judge in Crown Court ruled that therefore is a case of insanity, which seems a strange conclusion to reach, that because she couldn't remember putting these items in the bag, that was therefore a plea of insanity. So D pleaded guilty to avoid insanity as a defence and the label. So the Court of Appeal heard the appeal and quashed the conviction. D was not insane, she just simply lacked the mens rea for theft, hence she was found not guilty. So I think that's a sensible result. She may lack the mens rea for theft, but it's certainly nothing to do with insanity. So the Court of Appeal then set the test, and this is the test you will apply for Section B and Section C's. So, the Court of Appeal held that the rules of insanity only apply to persons who, by reason of a disease of the mind, are deprived of their powers of reasoning. They do not apply to those who retain their powers of reasoning, but in a moment of confusion or absent-mindedness fails to use them. So to paraphrase the test for the defect of reason set by Clark, what you are looking for is deprivation of powers of reasoning rather than a failure to use. So deprivation rather than failure to use. Okay, it'll make a little bit more sense once we do some Section B's and C's. Okay, so the second part of the defence is disease of the mind, DOM. The defect of reason must be due to a disease of the mind. The disease of the mind is a legal term and not a medical term, which is a problem. It means the judges have deciphered it and defined it. The disease can be a mental disease or a physical disease as long as it affects the workings of the mind. Okay, so various conditions have been included by the courts over the years. So these are the kind of things you might see in the exam. So it's epilepsy, sleepwalking, diabetes, schizophrenia, brain injury, psychosis, post-traumatic stress, manic depression, dissociation. So there are others, but they're the sort of main ones that you might see in the exam. Okay, so Kemp is another important case. The reasoning being is this case defined what is a disease of the mind. So Kemp was suffering from something called arteriosclerosis, which is, in non-medical words, hardening of the arteries. So basically you have fatty deposits in your arteries which reduces and restricts the flow of blood to the brain. It can cause blackouts and a temporary loss of consciousness. And that's what happened. So during one of these episodes, he attacked his wife with a hammer, causing her serious injury and was charged with GBH. it was clear that Mr. Kent was a very devoted husband, and so there was no malice, and he clearly didn't intend to attack his wife. He had suffered this blackout, which seemed genuine on the medical evidence. So you've got an issue here. Yes, he's had a malfunctioning of the mind, but it's not something like schizophrenia or depression. It's been caused by a physical part of his body, the physical in non-medical speak, such as a furring of the artery. That's not something that you'd imagine would be classed as insanity. So the question was, could this amount to a disease of the mind, since it was caused by a physical matter rather than a mental issue? Okay, so at the trial, Dee admitted he had a defect of reason, because certainly looking back at Clark, he had been deprived of his powers of reasoning. He didn't choose not to use them, he'd completely blacked out. So he was deprived of his powers of reasoning, and he agreed to that, but argued that this was not due to a disease of the mind because it was a physical and not a mental illness. So instead, Dee raised automatism in order to avoid the label of being called insane. Nearly every defendant does this. Wherever there's a malfunction of the mind, they'll always try to raise automatism, because that can lead to a full acquittal. Not always, but can lead to a full acquittal, and also it comes with no label at all. So he raised automatism as a result. However, the Court of Appeal held that this was a plea of insanity, so upheld the special verdict. Court of Appeal held that as arteriosclerosis was an internal condition, it had to be dealt under insanity and not automatism. So what was really important about this case is not just that a physical disease can be internal and therefore insanity, but the Court of Appeal set the test, so defined what is a disease of the mind. So Devlin J argued that the law is not concerned with the brain but the mind, in that the mental faculties of reason, memory and understanding are affected. The condition of the brain is irrelevant, and so is the question whether the condition is curable or incurable, transitory or permanent. So it's a bit wordy. What basically it's saying is it can be physical, can be mental, can be physical, as long as it affects memory, reasoning, understanding. So it doesn't matter whether it's there all the time, or it's temporary, or it's curable, it doesn't matter. So the key thing for me is I get my students to put the word RUM together. It just makes it easy to remember. You're looking for something which affects RUM. Reasoning, understanding, memory. So it's playing around the words, but it helps you remember the test. So anything that affects the defendant's reasoning, understanding or memory, whether it's physical or mental. So that was the definition of disease of the mind. And then the second thing we need to know is not just the definition, but which conditions fall under which defence. So next question, which is there. How do the courts define what amounts to a disease of the mind? We know we've got the definition, but then we need to categorise which conditions go under which defence, insanity or automatism. The answer to that question is as follows. There are two different tests. They are both different, they are both non-medical, and the condition that you're looking at in court could be a different defence depending on which test you use. So we've used this line of reasoning various times since September. Two different tests, both different, and both can bring about different results. Another reason why Parliament need to intervene and reform. So just to mention those tests briefly, the examiner would expect that he had some knowledge of the two tests. The question as to whether a condition is insane or non-insane automatism, for us insanity or automatism, is a question of law for the judge to decide. So he must decide whether the right defence is in court. The courts have devised over the years two main tests, so there have been others, but these are the two main ones. The continuing danger theory, which we can call the CDT, and secondly the external cause theory, which we can call the ECT. So, in summary, the CDT suggests that whatever condition the defendant has, if the condition is likely to recur again and again and again in violence, then this has to be considered insanity. I tend to think logic. If it's something that's going to recur in violence, it needs treatment. How will you get treatment? Insanity. Yeah. However, the opposite also applies. So under the CDT, if D has suffered a one-off, isolated incident through a condition, then that is suitable to an acquittal, which will be gained through automatism. So next to the 2 bullet points, if a condition recurs under the CDT, that is insanity. Under the CDT, if it's a one-off isolated episode, that relevant defence will be automatism. The aim of the CDT is to protect society from violence, so that's where it comes from. The ECT suggests that issues stemming from psychological or emotional factors rather than external factors should constitute insanity, i.e. internal matters equal insanity, external issues constitute automatism. So the 2 bullet points there, internal cause equals insanity. Again, logic, if it's internal, it needs treatment, therefore it's insanity. External causes are deemed automatism. Again, logic suitable to an acquittal. So there are some similarities between the 2 tests, but there are differences as well. So some conditions will be the same under each test, but then there are other conditions where it will differ dependent on which test you're using, the CDT or the ECT. So in other words, we just need Parliament to intervene and give us one test that works. So neither are perfect, and there are problems with each of the tests. So what are the problems with these tests? The CDT, main problem with the CDT is that not all recurring issues should be classed as insanity. So certain things that recur, so I'll give you an example there, e.g. epilepsy. People have epilepsy and there's lots of different types and different levels of severity, but in general, being a non-medic, but in general, epilepsy is something that can recur. So under the CDT, that is insanity, which is unjust, it's absurd. There's no epileptic in the world that should be classed as insane. So the CDT would make a wrong call in there, but that is how it would work out. Because it recurs, epilepsy would be insanity. But equally under the CDT, sometimes one-offs that do not recur should be insanity. So for example, it could be a one-off psychotic episode which might need intervention and treatment. That should be insanity, but it wouldn't be because it doesn't recur under the CDT. Also the ECT, internal matters, so this is the problem with it, internal matters should not always be insanity. So we've just quoted one above, epilepsy is internal, but it should not be insanity. Also diabetes, certain types of diabetic seizure are classed as internal and should not be insanity. And again, sometimes external matters, external one-offs, should not always receive an acquittal. So that could be somebody abusing medication. And also, a further problem with the ECT is sometimes a condition can be triggered by both internal and external factors. And if that's the case, you can't even use the ECT. I'll give you the example of the epileptic walking down the catwalk at some big show in London. The epileptic walks down the runway, the red carpet, and then the cameras are flashing. That person, his or her condition is internal, epilepsy is an internal condition. But yet what triggered the seizure is the flashing photography. So in that example, there's an internal and external factor. So the ECT would be completely useless because the ECT says it's got to be internal or external. So it shows that the test is not medical and it's not fit for purpose. Okay, so next couple of cases just talk about the use of these tests. And then we get into the conditions such as diabetes, dissociation, etc. So Bratty first of all. So this was a defendant who killed an 18-year-old girl by removing one of her stockings and then strangling her with that stocking. On arrest, he admitted his actions, but claimed that something had come over him, a terrible feeling and a sort of blackness. He further explained that the murder took place during an epileptic seizure. So he's killed this young girl and he's citing epilepsy as the cause. The trial judge said that this amounted to insanity, so the defendant appealed, and when it got to the House of Lords upheld the special verdict. This was insanity. Epilepsy is a disease of the mind and therefore insanity rather than automatism. So this case told us epilepsy is insanity. Now what was really important in this case is that it created the CDT above, and it was Lord Denning. Lord Denning said, first of all, he approved Kemp, which defined what is a disease of the mind. And then he stated the following words: it seems to me that any mental disorder which has manifested itself in violence and is prone to recur is a disease of the mind. Highlight, this created the CDT. So this is where it came from in this case. Incidentally, in any case where insanity succeeds, just to save you time in the exam, instead of writing not guilty due to the reason of insanity, it's quite a long phrase that, not guilty due to the reasoning of insanity, write it once and then brackets NGRI, not guilty, reason, insanity. So you can write that at the side of bracket NGRI, not guilty, reason, insanity, which is also known as the special verdict. Okay, now, so that was 1963, so we're going back a few years now, but to show the inconsistency in the judicial approach. Charleston was 1955, so a few years before, and this was D. He'd invited his son to come and look out of a window. He'd seen that there was a rat swimming in the river below the window, so he invited his son over to come and peer at the river. D then picked up a mallet and struck the young boy on the head and threw him out the window. D knew that he was killing the boy but had no idea why, but he was suffering from a brain tumour. It was held that the tumour was a physical disease and not a disease of the mind under McNaughton, so the jury acquitted, allowing automatism. So that provides a problem, because had that been decided after Bratty, the result would have been completely different. So question? How would this have been decided under Lord Denning's test? Well, Lord Denning has just created the CDT, which is about recurrence. Charleston's condition is very likely and probably did recur. So if it had been decided, let's say 1965, the result would have been NGRI. He would have been found insane. So it just shows this non-medical, inconsistent approach between different judges. But as it stood, because it was before 1963, he succeeded with the defence of automatism. Right, so the last case on the tests, before moving to condition by condition, was the case of Sullivan, 1984. Again, a second epilepsy case. D was 51 and he'd suffered from epilepsy since he was a child and had shown aggression during fits when people came to his aid. There's lots of different types of epilepsy and, like I said, lots of different levels of severity. But there is one particular type where they won't know they're doing this, but where the person is suffering from a seizure, they will kick out and hit out and become abusive to anybody who comes to their help. And this is what happened here. So one day, he was sitting in his neighbour's flat with his friend, Mr. Payne, aged 80. The next thing he recalled was standing by a window whilst his neighbour was laid out on the floor, and he was charged with GBH. So the trial judge held that this was a plea of insanity. So trial judge dash NGRI. Hence, D pleaded guilty to GBH to avoid the label. Now this happens in quite a few cases, and a lot of defendants, as soon as insanity gets mentioned, they'll automatically plead guilty and rather go to prison than receive the label. So this is what happened here. As soon as insanity was mentioned, the defendant preferred to instead plead guilty and go to prison for GBH, which does seem really harsh. On appeal to the House of Lords confirmed the conviction and rejected the appeal. Although they sympathised with the defendant, they held that this was a case of insanity using the CDT. So what Sullivan did was confirm the CDT. So just before we finish with that case, just put next to Sullivan dash QSH. When we did this special study, it got very confusing as to which defendants pleaded insanity, which pleaded guilty. So just to make it a little bit clearer, hopefully, QSH, those are 3 different cases where all 3 defendants pleaded guilty to avoid the label of insanity. So QSH stands for Quick. That's the name of a defendant, Quick, Sullivan and Hennessy. QSH all pleaded guilty to avoid insanity. So in this case, the ultimate ruling was it would have been insanity, but it wasn't because D pleaded guilty instead. So moving on from the 2 tests, we're still on the same section, which is dealing with what is a disease of the mind. So we've got the 2 tests, and then the next section is just looking at different conditions that have been discussed or categorised as insanity, as well as other defences, namely automatism, the second defence. Okay, so the next section is a common section which also features on the automatism handout, and the reason for that is, apart from epilepsy, DDS, dissociation, diabetes and sleepwalking both form part of both defences. So dissociation can be sometimes insanity, sometimes it is automatism. Diabetes is also both, it's covered by both defences, and sleepwalking as well can be covered by both defences. So just to make it easier in terms of revision and recall, what I've done is just keep the section the same and cut and paste it on both handouts, but because it's quite technical and quite medical, it makes sense to go through it in detail just to make sure that we've got this section clearly. On the automatism video, I sort of rush through this really briefly, so this is probably the best place to sort of go through each condition in detail and explain the law on each point. Okay, so we've got 4 conditions that we're going to talk about. The first one we have just touched on above because it affects the 2 tests, which is epilepsy, which has only ever really been discussed as one thing, which is insanity. And then we've got the 3 conditions, DDS, which can be both. So epilepsy first. So this is again a classic disease of the mind. Epilepsy is a functional disease of the brain, characterised by seizures, and it affects several 100,000 people in the UK, so most likely much more than that around the world. However, in the House of Lords, in both Bratty and Sullivan, they branded epilepsy as only ever constituting a plea of insanity. So really, every case has always said one thing for epileptics and the condition epilepsy, that it is categorised as a disease of the mind, and therefore it is dealt with under insanity. Now, question, how is that ruling criticised? If you went to any doctor, or even better, any person suffering from epilepsy, and asked them whether that should be insanity, they would be absolutely ridiculed. There is no way in the world that any condition such as epilepsy should be dealt with as that person is insane. So this is how out of date and how non-medical this defence is. So the ruling's been criticised heavily by so many people. Number one, it's a very, very unfair label for anyone, but extremely unfair for somebody suffering epilepsy. There are lots of different types of epilepsy, different levels of severity, but most can be dealt with successfully with medication. And it doesn't matter whether it's severe or minor, it should never ever lead to a label of insanity. The second point as to how this is criticised is it's not a medical ruling. There's no medic in the world, never mind in English jurisdiction, who would say that epilepsy should be dealt with as insanity. Not one single doctor. And the third reason why this is heavily criticised is that because we are dealing with several 100,000 people, it just doesn't make sense. What we're saying on this condition alone, we have got several 100,000 people that are insane in the UK, which is ridiculous. When we add on the other conditions, you're talking about millions of people that are potentially insane. So none of it works. The label is wrong. It's not in line with medical thinking, and certainly the fact it's branding hundreds of thousands of people insane is clearly very wrong. So again, it's something that Parliament desperately need to reform. Okay, just so we've got the context, Brattett and Sullivan, which we've just looked at above, that both looked at and discussed the CDT, both confirmed epilepsy is something that is classed as a disease of the mind, hence insanity. So just put a keyword next to each case, because we've just done these cases. Brattett was the 18-year-old stalking murder. And then we've got Sullivan, which is the 80-year-old neighbour, and the defendant who had very violent form of epileptic seizures. Just a note at the side for both. Both cases confirmed the relevant defence is insanity. Okay, so now we're into DDS, dissociation, diabetes, sleepwalking. Okay, so these conditions sometimes are considered disease of the mind, hence insanity, and on other occasions the judges will say that in fact it's the second defence, which is automatism, which is a massive difference. With insanity you're getting this really, really bad label, plus it could lead to hospitalisation, that can be indefinite for murder, for example. Whereas with automatism, that can lead to a full acquittal with no label. So actually the fact that these conditions can cover both is clearly wrong. Right, dissociation first. So this is something that might be new, as it's quite unusual. Dissociation is a condition that causes a defendant to act in a trance-like robotic state, which is usually caused by an extraordinary life event or an overwhelming amount of emotion. So just from what I've read looking at these cases, usually it's something major that's happened to this person that triggers a robotic trance-like state, and they have something called medically a fugue, which means they're just seeing tunnel vision. They might look and perform actions and they might look sort of semi-normal, but in fact they're in this sort of zombie-like, trance-like state. Like I say, normally triggered by huge life-changing events. So, however, the courts have said this can be both insanity, it can also be automatism. And how they differentiate the two defences is the trigger of how that state has come about. So, question, when is dissociation considered automatism? And when is it considered insanity? So, first bullet said extraordinary events and stress. If something really, really major has happened to D, which anybody in their right mind would have an unusual effect or would be really shocked, really significant life-changing event, because that's a one-off and because it is so serious, you would expect anybody to be acting differently. So as a result, extraordinary events and stress dash a one-off equaling automatism and therefore an acquittal. So just write that aside, extraordinary life events equals a one-off dash acquittal dash automatism. So I don't know, just to give you some examples there, just things that have come up in the news, but like these aeroplanes that have gone missing, where whole families have been, wiped out. That would be, if you're a person that's still back in the UK and your family are missing, until they are found, that is such a life-changing, significant event that if you or I had an unusual reaction and a state of dissociation, that would be triggered externally, and also it would be triggered as something that would deserve a full acquittal. It's clearly not that defendant's fault. Secondly, however, some defendants have suffered dissociation where the trigger has just been an ordinary part of life. So any state of dissociation which is induced by ordinary, even, stresses of life, everyday events, then that is everyday life and classed as insanity. So just write that aside. Induced by ordinary stresses and parts of life is insanity. Why? Because that defendant needs treatment. So let's just say in college somebody stole my favourite Lord Denning textbook. Yep. And I went into a one-off trance-like robotic state and start committing serious assaults, murders, etc. That would mean I need treatment. That's insanity. That's not normal to just on a minor theft to go into such an erratic state of dissociation. So it makes sense, really. Think about the logic and the repercussions of each successful defence. So big trigger, automatism. Small trigger, insanity. So we've got a set of cases each side to show how this works. And we'll start out with the small trigger cases, ordinary stress cases. So we've got the case of Raby, which is a Canadian case. Often we have to use Australian, Canadian cases where there's a lack of English law. So in Raby, Dee was a 20-year-old university student studying geology who had an attraction towards a girl at college who regarded him as nothing. So he'd overheard her talking about him and she was just describing him as nothing to her. So that was clearly upsetting to him. He'd taken a rock from school for his work and then met up with this girl, at which point she stated that she considered him just a friend. So again, that upset him as well. He hit her over the head with the rock, and started to strangle her. So this defendant was charged with GBH and pleaded automatism. Every defendant worth their salt will always try to plead automatism. Even if they know it should be insanity, you'll always try to plead automatism because you know it's the better defence. It could be an acquittal and you don't get this label. So that's what he did. He pleaded automatism based on a state of dissociation. And certainly when the witnesses found him at the scene, he was clearly in a different state. Clearly, not acting normally. So the trial judge, in fact, accepted the defence of automatism. So unusually, the prosecution appealed this time and said, this can't be right. This is an everyday part of life. People will be refused and turned down many, many times, daily, weekly, and it's not right to go into such an extreme state of dissociation. So it got to the Supreme Court in Canada, at which point it was held that such ordinary stresses and ordinary parts of life do not constitute an external cause and therefore are not automatism. So what it did, the court reordered a fresh trial, so retrial was ordered. What happened on the retrial we'll never know because that was not recorded, but I can guess between the lines. Since the higher court said this is insanity, I am guessing, totally me guessing, but I'm guessing that the defendant would have pleaded guilty as he wouldn't want to be labelled insane. But the legal principle of this case still stands, that everyday stresses of life, such as unrequited love, is not automatism. The relevant defence is insanity. And clearly that works because that type of defendant needs treatment. Okay, second case of everyday life style events. Stone, another Canadian case. The Supreme Court of Canada followed its own decision in Raby. This defendant pleaded automatism again to murder of his wife. The evidence that he suggested in court that he'd been sat in a car with his wife and then a whoosh sensation, whatever that is meant to mean, came over him, and as a result he stabbed her 47 times. Now his evidence was that his wife had been verbally assaulting him and insulting him. So this whoosh had come over him and then he stabbed her 47 times. The trial judge held in this case that if anything this had to amount to insanity. As a result, D was convicted of manslaughter and he appealed. Where it was held, the relevant defence is insanity. Being insulted by anyone, wife, husband, friend, anybody, is an everyday part of life. So if that leads to dissociation, that has to be treated and therefore it's got to be insanity. So those two first cases show us small trigger is insanity. Right, now we get to the extraordinary stress cases where you've got a one-off huge life event. Now these can be considered automatism, the second defence. Okay, so the first case is the case of RVT of 1990. Now, strange label and naming of the case, but this is because the defendant was also a victim of a previous sexual assault. So her name was not revealed in court, understandably so. So in T was a lady who had been raped recently, before the act took place, and was suffering something which is a well-known condition, PTS, post-traumatic stress. And it was days later she was charged with robbery, having stabbed the victim. She'd gone into a shop and used some sort of weapon and was charged with committing robbery. Now, in the case, what was key to this case is that the defendant had some control over her actions, but she had acted in a dreamlike state. So she had driven to the shop, she walked into the shop, she was acting with purpose, etc. But that's often what can happen in states of dissociation. So this was considered, bearing in mind the trigger this time is an external sexual assault, this was considered an external cause. So the trial judge said that this, if any defence, will be automatism, because being sexually assaulted is such a big life-changing event that anybody would act differently, certainly in the days afterwards. So the trial judge said, yes, this is allowed, this will be allowed to go to the jury. So he allowed automatism to be placed before the jury's consideration to see whether or not it could succeed. In a very unusual move, the jury didn't buy into it and the jury rejected the defence and convicted the defendant. So that seems really harsh, but we'll see in the next case that there is an issue with the evidence. So, question, what were the issues that were discussed in this case? The prosecution's evidence was that the defendant had acted with complete purpose. So everything that she'd allegedly done was done with a clear purpose, and in effect like any other normal person doing that exact act. Clearly that was convincing for the jury. Also, what was important in this case, and you'll see this with automatism, about the degree of consciousness. The issue with consciousness is that it's not an absolute. You might have seen people with seizures, or you might have seen somebody pass out. It's not that somebody's 100% conscious and they're 0% conscious. Normally there are different degrees, so somebody will be a little bit dizzy, feel a bit ill off it, and then will slowly lose consciousness. Not all the time, but mostly that would be the case. So, second point to note, that the court in this case accepted that partial consciousness is sufficient for automatism. But still a legal principle from T, and you might want to note this at the side, that this case showed that one-off external life-changing events can be automatism. Just not this particular time, as the jury rejected it. But, T is showing that big triggers, big life events, if anything, is automatism. So in future case, it could be automatism. Okay. So, however, the validity of T has recently been undermined by a more recent case of Narborough in 2004. So this was D stabbed V with a Stanley knife and was charged with wounding, but he argued that he'd been sexually abused as a child, which had left him post-traumatic stress and flashbacks of the abuse. At the time of the offence, D argued that he was in a state of dissociation, and so he was acting in a zombie-like state. Now, when the medics looked at the evidence and the lawyers looked at the evidence, they felt that this could not succeed. When they looked at it, they looked at two different issues. Post-traumatic stress, we all know that definitely exists. Any medic in the world will say post-traumatic stress definitely exists. Also, any psychiatric doctor will also probably tell you, I'm not a medical expert, but would also say that dissociation also exists. But when you look for the evidence linking the two, that PTS can lead to dissociation, there isn't any evidence. So what I'm saying there is, yes, PTS exists, and yes, dissociation exists, but there is no medical link between the two. So actually, maybe this defendant did intend the crime, or in fact, maybe he did not suffer dissociation. Who knows? But what we do know is PTS, which was most likely most genuine, could never have led to dissociation if that happened. So it was held that automatism could not succeed, since there was no evidence that PTS could lead to any defendant losing control and being in an automatic state. So that in turn undermines T, where she had suggested that the PTS had led to the automatic state. So I'm not going to say what is right or wrong, I'm not a medic, but looking at the medical evidence, PTS definitely exists, so does dissociation, but there isn't a link between the two. So we'll have to wait and see what happens next on that score. Okay, the next big trigger case then is Falconer, which is now Australian. The defendant was convicted of murdering her husband with a shotgun. But she gave evidence of a very violent marriage, and she'd just received a phone call that particular day, just when this had all happened, that her husband was being charged with sexual assault of her two daughters. Also on that particular day, on the day of his death, the husband had also sexually assaulted the defendant as well. So this is a big life-changing set of events, that she finds out the news he's abused her daughters, and also that he'd in fact abused her on the same day, plus the history of the violence and the violent marriage. She couldn't remember nothing from that point onwards until she found herself on the floor with a gun beside her and the husband was dead on the floor. It was held by the High Court of Australia that automatism could succeed on the grounds of dissociation, why the trigger this time was an extraordinary life event, and therefore that could lead to a full acquittal. So automatism succeeded on the grounds dissociation, since this was a significant trigger, therefore deemed external. So the next condition is diabetes. So this is a very common disorder that is suffered by many people in this country and around the world. So this is a disorder of the pancreas which results in erratic quantities of insulin being produced. So people who don't have diabetes, their own bodies regulate the amount of insulin throughout the day. So when you eat something, your body will naturally secrete insulin to balance out the blood sugar. Diabetics have to artificially administer the insulin to sort of balance out the condition. Again, there are different types and there's different levels of severity, so I'm not going to get into the medical things about it, but in short, the type of defendants we're looking at here have had to regulate their own insulin. So injections of insulin are needed normally to control the body's blood sugar. If the sugar levels gets too high or too low, then a seizure may result, which can lead to unconsciousness and eventual coma. Where people act unpredictably, sometimes committing thefts or assaults, will be on the onset of the seizure, where the diabetic can become violent and aggressive. So it's often as they're going into the seizure, that's the bit that they may not remember, they won't recall, but they've gone into a seizure type state. Okay, so first question, should diabetes be considered insanity? Should it be considered automatism? The answer there is absolutely no. Should never be considered insanity. Millions of people have diabetes. They have it, they control it successfully, and there are relatively minute number of cases, relatively one or two, so many few cases where people have resulted in seizures which have resulted in assaults or thefts. You just don't really hear about it. It's really, really, really rare. So for the millions that have the condition, it should never be classed as insanity. And again, if we ask doctors a medical opinion, no doctor would ever confirm that insanity should cover diabetics and diabetic seizures. So it's out of line of medical thinking. And the same with epilepsy. Again, the label. How dare the courts label any diabetic person insane? It's ridiculous. It's so unjust. Again, Parliament need to look at this. Okay, so there are two types of diabetic seizure. So unfortunately this is a little bit wordy, but students manage it each year, so you're just going to have to be careful on the wording and the spelling of the seizures. So there are two types of seizure. Hyperglycemia, which is high blood sugar, which is where the defendant has not taken any insulin or not taken enough to manage the blood sugar. And of course that can trigger a seizure. The second type of seizure is called hypoglycemia, which is low blood sugar, which means the defendant has taken too much insulin or taken his regular amount and not eaten enough. And again, that triggers a similar seizure. So the seizures are medically quite similar. It's just whether or not the defendant hasn't taken it or whether he's taken too much and not eaten. But really, to all intents and purpose, this defendant is basically, whether it's hyper, is effectively, it's the same type of seizure. But still, one is classed as insanity, one is classed as automatism, which is completely ridiculous and unjust. So hyper, the way that I recall and sort of studied and tried to remember the two seizures, hyper high, think about it, hyper high, your blood sugar is getting higher and higher and higher internally. Because that's internal, that is classed as insanity. So that's the way I tell students to recall it. Hyper high insanity. Hyper high insanity. Your blood sugar is getting higher and higher and higher. It's all inside the defendant, so therefore it's internal, therefore it's insanity. Hypo-low, so hypoglycemia. Hypo-low, the thing that triggers the seizure is the insulin. That's external. And that's why the courts have ruled that to be automatism. Still completely unjust, but that's the logic of the judges. Hyper high insanity, hypo low external automatism. So we've got two cases which illustrate both seizures. We've got Hennessy first of all. So Hennessy is one of the QSH cases, Quick, Hennessy and Sullivan. And as I said on the last bit of the presentation, the video, that QSH, all defendants pleaded guilty just to get rid of the possibility of insanity. So in Hennessy, he was a diabetic and he'd not taken his insulin for several days when he suffered a hyperglycemic seizure. So this is because he's not taken any insulin at all. During this event, he was charged with taking a vehicle without the owner's consent, and he was also driving without an adequate licence. Whilst disqualified, he had no memory of even driving the vehicle, and it was held that because of the cause of the episode was his diabetes inside, he'd not taken anything external, it's his sugar inside getting higher and higher, that was therefore insanity. However, as we said before, and I just note this next to the name of the case, Hennessy pleaded guilty would have been insanity. So we can't say it was because he pleaded guilty to get rid of that label, but pleaded guilty would be insanity if he went for any defence. But maybe not on the facts of this case, because clearly the defendant seems pretty culpable in leaving his insulin for 3 days. He must have known what exactly would occur. Just from a personal example, I have a family member who got diabetes, and I believe this to be common from other students and staff that have the condition. When you first get the condition, it takes a while to work out if you have a big meal, you need more insulin, and one day you eat less, you need less. Getting the rhythm quite right, it's quite difficult to get that balance. So certainly for the first weeks and months, maybe even the first year, that defendant who might have a seizure, it might not be their fault. It could be that they're just trying to get the medication right. So it seems really harsh and indeed ridiculous to say that hyperglycemia, as in Hennessy's case, would be insanity. Clearly on the facts, he's very culpable, so I'm not talking about him, but I'm talking about the fact that this case is saying hyperglycemia is insanity. Quick. So this was an unusual case. William Quick was a diabetic who was also a nurse on a psychiatric ward. So he'd taken his insulin as he knew he had to, but then he ate very little afterwards, and there was evidence that he'd drunk a quantity of alcohol as well whilst on shift, which triggered a seizure during which he attacked a patient on the ward. Quick was found actually sat on the patient, unable to talk and glassy-eyed. So Quick had absolutely no recollection of what he had done as he was in this hypoglycemic seizure. So on appeal, it was held that the cause of his episode was the fact he'd taken the insulin, the drugs, and not eaten enough. Therefore, this was an external cause, therefore this would be automatism. Now, because it's QSH, again, this was guilty. He pleaded guilty in order to removed the possibility of insanity. What happens, to give you a bit more information that you might need to write on the handout, was the trial judge incorrectly said that this would be insanity. Because it's so confusing, sometimes it's one defence, sometimes it's the other, that the judges do get mixed up. So the judge had incorrectly said that it was insanity. So the defendant pleaded guilty as a result in the Crown Court to avoid this label at all. However, on appeal, the Court of Appeal said, no, it's automatism. Hence, automatism succeeded on appeal. So the next, or the final category of DDS is sleepwalking, which the medical term for that is somnambulism. But it's fine to use the sleepwalking word phraseology in the exam. So this is a sleep disorder, which is very common in children. Most children do have episodes of sleepwalking, but also it's present in a very small amount of adults. For many years, these defendants who slept walk and committed crimes were considered under automatism rather than insanity. Think about it, how many cases do we see in the news where people in sleep have committed major crimes? It's so rare, so when they have happened, traditionally the courts have said that's a one-off and therefore can be automatism. However, because of the reliance on the ECT, external cause theory, it has meant that the condition has now been often deemed insanity, which is dangerous. That means most children growing up have pockets of insanity when they sleepwalk, which again is just not medical, and the label is completely unjust. Now, the reason why the ECT points towards insanity is often people who tend to sleepwalk, not always, but often when people sleepwalk, it's sometimes due to disturbed sleep patterns, sleep disorders, and of course that's internal. So if you're following the ECT, that means it will be internal insanity. So it is predicted that there may be around 2 million people who sleepwalk in the UK. So again, the combined effect of epilepsy, diabetes and sleepwalking is, we are saying, or the courts are saying, that there are millions and millions of people in this country that are insane, which is clearly absolutely ridiculous. It does show Parliament definitely need to reform, because that does not bear logic. And again, it's not medical. So there are 3 types of sleepwalking condition that have come before the courts. We've got sleepwalking, night terrors, and sexsomnia cases. So we've got a few cases to discuss which illustrate the different types. First is the case of Burgess, which is a big English case. This was one evening the defendant Barry Burgess and his friend Katrina Curtis were watching videos in his flat when they both fell asleep. Now, the evidence he put forward is that he'd been sleepwalking, and during his sleep he had attacked Katrina with a wine bottle and a video recorder, which at the time in 1991 would have been quite a sizable electrical piece of equipment. And he then grabbed her around the throat. So he pleaded automatism, having assaulted her. Now, Lord Lane said that sleepwalking was an abnormality or disorder, albeit transitory, i.e. temporary, not permanent, but was due to an internal factor. So Lord Lane relied on the ECT and said because sleepwalking is internally triggered, therefore this had to be deemed insanity. So when you look at the defendant, when you look at the cause of his sleepwalking, if indeed it happened, He'd had a sleep disorder, so if you're using the ECT, then that has to be insanity. So, question, how did the court also possibly view dissociation in this case? There was a suggestion that dissociation was the condition that he was in fact suffering and not sleepwalking. So dissociation had been discussed in the trial as well. Now, the dissociation was suggested that he had interest in Katrina, let's say, and she had rebuffed him. She wasn't interested in a relationship. So this unrequited love potentially triggered a state of dissociation, which is what happened, stroke, or it was sleepwalking. So how did the court view that? It was suggested that if it was dissociation that defendant was acting under, then that was due to unrequited love, which is an every part of life. So therefore that would be still insanity. So in other words, it doesn't matter whether you consider this sleepwalking or dissociation, the trigger is internal. Whichever way you look at it, it would have been insanity. So just to make that clear, side of Burgess, internal, cause, insanity. However, again, we're looking at a Canadian case. The Supreme Court of Canada have taken a different view, and we have a different case to illustrate here, which is Parks, 1992. So this defendant got up in the middle of the night, he got dressed, he got in his car, he drove 15 miles to the home of his in-laws, where he stabbed and killed his mother-in-law and severely injured the father-in-law. Throughout the whole sequence of events, Dee had apparently been sleepwalking. That was the evidence. So Dee was charged with murder and attempted murder. The Supreme Court of Canada accepted automatism and upheld an acquittal for both charges. So Dee was set free and acquitted. So that looks mighty strange that we've got two sleepwalking cases. One is insanity, one is deemed automatism. However, where you scratch below the surface, there is a crucial difference between the two cases. So what are the critical differences between Burgess and Parks? Burgess, the cause was an internal sleep condition. So clearly that would be something that could recur, it's internal, so that needs treatment. So we could suggest that Burgess was decided as it was because it was an internal sleep disorder. Parks, the evidence was he was under extreme stress at work. So this extreme stress at work, which was external, it was a one-off, had triggered this sleepwalking event. So when you scratch below the surface, there is a critical difference between the two. Maybe that justifies why one is insanity and why one is automatism. Burgess was internal and Parks was externally caused. So just to make it consistent, next to Parks, just put external cause to make that clear. So that still leaves us with a question mark, and it's something that I've never been able to answer. Does that mean Burgess is suggesting all cases of sleepwalking in English law are insanity? Or alternatively, was it just on this set of facts because it was an internal sleep disorder? And there is no answer to that, other than Parliament do need to reform the whole of the defence, not just sleepwalking. Okay, and then what has happened in the English courts since 2005? Well, two cases have occurred, pretty recent, which have put a big, huge question mark over the whole area of the defence and sleepwalking, the condition. So two cases. Bilton, first of all. In Bilton, this was a young man who'd been drinking with a young girl in a bar, and then there was a gang of them that had gone back to a flat or a house, and this defendant was charged with rape. He'd woke up in his sleep, and during his sleep, He was found to be having sexual intercourse with the girl, but he was clearly very distraught at the time, so it was clear whatever had done, whatever had happened, he was in a state of sleep. When they looked at the medical evidence, he'd had quite a significant sleep disorder since being the age of 13. So this defendant clearly had a sleep disorder that was very evident. Now, so this went to the court, the Crown Court, and it was York Crown Court. And when you look at this is an internal disorder, so you would imagine that this is insanity. However, the Crown Court in York said no, automatism could succeed. Wow. So this puts a massive question mark, massive cat among the pigeons over everything we've just said. This case is telling us that even though it was an internal sleep disorder, it could be a one-off acquittal, hence automatism. So that certainly needs to be looked into because that's not consistent with Burgess. The second case, which was quite a famous case in the news and very upsetting case, was the case of Brian Thomas in 2009. So this was an elderly couple and they'd gone on the holidays, Brian Thomas and his wife, and they were staying in a caravan. I think it was somewhere in Wales. So they were staying in this caravan and a gang of youths had been abusive and tried to assault them around their caravan. So that's very scary stuff for anybody, never mind an elderly couple. So these youths have been terrorising them. Then both Brian Thomas and his wife fell asleep, but during his sleep he suffered a night terror. And so in his sleep he attacked what he believed was an intruder. So he relived this event of these youths being in his caravan, he attacked the youths, but in fact what he'd done is kill his wife. Again, when they looked at the medical evidence, he had a long life history of sleep disorder. So, he was charged with murder, and I never forget this case because it was so sad. This is an old man who was absolutely broken. He was on the court steps, his daughters were holding him up, and it was absolutely in pieces. It was clear that this was done in sleep. So, he was charged with murder, and the only defence that looked possible was insanity, because this is an internal sleep disorder. Now, very unusual move, the prosecution, who were paid to convict, withdrew the murder charge. When does that happen? The prosecution are paid to convict, yet the prosecution withdrew the case and said that's it, we can't do this. That shows us, if the prosecution are withdrawing, that shows us that this has to be reformed, it has to be looked into. So the prosecution withdrew the defence because we clearly knew this was going to be insanity, which for such an elderly man, that just didn't seem fair. So both Bilton and Brian Thomas are both telling us one thing, which is that not only does insanity need to be relooked at overall, certainly sleepwalking needs to be either decategorised or researched, or something has to change, because the courts, the prosecution, nobody seems to be following what Burgess is suggesting. So before Burgess, indeed, the courts always seem to prefer automatism anyway for cases of sleepwalking. So we just need the answer, is insanity the right defence, or is it now automatism? So it's in a real state of flux. Right, so that completes the disease of the mind section, which is the biggest section. Now we proceed on the third element that D has to prove. So D has to prove, number 1, defect of reason, number 2, disease of the mind, and number 3, nature and quality. So for nature and quality, which is this last section, D, it's an either or this time. So D must either need to prove that he didn't understand the nature and quality of the actions that he undertook, or if not, then he must be able to prove that he was unaware that he was doing something that was wrong. So just to give you two examples of defendants who were able to prove the third part of the defence: Kemp and Burgess. Now remember, it's an either or, but both these defendants would be able to establish both. Kemp, this was the guy who suffered from arteriosclerosis and the hammer attack, and his wife, the third up artery, all of that. Yeah. When he suffered the seizure, the blackout, he was effectively unconscious and out of it. Therefore, if you look at the first part, nature and quality, did Kemp understood the nature and quality of what he was doing? So the nature, the physicality of it, and the reason why? Of course, no, he didn't understand nature and quality because he's unconscious. Also, would he understand that he's doing something that is wrong? Well, no, at the time, he was unconscious. So he wouldn't understand nature and quality, and he would not understand he's doing something wrong at the time. So he would be able to prove the third part of the defence. Another example, Burgess, which we just looked at, which was the sleepwalking case with the VCR and the wine bottle, and he attacked his would-be girlfriend in his sleep. Did he understand nature and quality of what he was doing? Absolutely not. He was asleep. If we believe his evidence, he was asleep. Therefore, he doesn't understand what he's doing and why. And also, would he understand that he's doing something wrong? Well, no, because at the time he was asleep. He wouldn't have appreciated that he was still doing something wrong. So you don't need to tick both boxes, but those both defendants would be able to prove both. So, other examples. So I've just created some examples to show you the type of tricky areas that could catch students out in a section B or a section C. So the first example is where a defendant cuts off a woman's throat under the delusion that he's cutting a loaf of bread. So this defendant thinks he's cutting a loaf of bread. Clearly, he doesn't understand what he's doing. He doesn't understand the nature and quality of his actions. And therefore, he would have a successful plea of insanity because he does not understand the nature and quality. Secondly, the defendant chops off a sleeping man's head in order to see his reaction when he wakes. Again, this would be a successful plea of insanity, as the defendant clearly doesn't understand the nature and quality, so the physicality of his actions and what he's doing, because the man will not ever wake up. Then we've got a defendant who kills another man, deliberately kills another man, who he believes to be stalking him under a paranoid delusion. This defendant would understand nature and quality. He knows that he's committing murder. So he knows his reasoning, clearly his reasoning is delusional, but that is irrelevant to the defence. He knows he's committing murder, so he understands the nature and quality of what he's doing. So what he's doing and why. So that defendant would not get the defence. But that defendant is clearly very, very dangerous and does need treatment, if not hospitalisation. D pushes V off a bridge, believing that V is a kite. This defendant clearly does not understand nature and quality, as the victim is a person, not a kite. So that's N and Q cross. That defendant would get insanity. And then final example, D kills his teacher, believing her to be the devil. Again, this defendant does understand the nature and quality of his action. He knows he wants to kill his teacher because he believes she is the devil, so he understands killing, he understands the nature and quality of his actions. Again, his reasoning is flawed, but he understands what he's doing, i.e. killing, and why he wants to do that. So the two most dangerous, or two of the most, they're all dangerous defendants, but two very dangerous defendants there are escaping treatment, are escaping the defence of insanity. So that's the third example, the third bullet. And the last one, both of those defendants would understand nature and quality and therefore would not get the defence. Now, an AO2 point, just to note at the side, is many medical people and psychiatric type doctors would criticise heavily this part of the defence. When you think about some of the most insane people, some of the most delusional people, some of the most psychotic people and defendants, they will understand the nature and quality of their actions. They will understand murder is murder, that theft is theft, assault is assault. Couple of examples, the Yorkshire Ripper, for example, Peter Sutcliffe. Peter Sutcliffe and his defence tried to raise evidence that he was suffering from a medical condition, type of schizophrenia, whereby he was being instructed from God to kill and maim and assault women he deemed to be promiscuous in the north of England. When you ask Peter Sutcliffe, do you understand what you were doing? Do you understand that that was murder or attempted murder? He would clearly say yes. He understood exactly what murder was. He understood attempted murder. But what he tried to explain is that he was having these messages from another being. Clearly, this is a person who desperately needs treatment and would be an ideal candidate for the defence. However, it would fail for Peter Sutcliffe and such like defendants because he understood the nature and quality. He understood he was committing murder or attempting murder, and he knew the reasoning why that he'd been instructed from a higher being. The fact that he was delusional, that's irrelevant. He understood the nature and quality. So that's the problem with this section of the defence. Your most dangerous psychotic type defendants nearly always understand nature and quality of what they are doing. Often they just can't stop themselves from doing it. So we had a case with diminished responsibility, R.V. Byrne. Again, that defendant knew exactly what he was doing, just couldn't stop himself. So when you asked, did you understand the nature and quality of your actions, he would say yes, therefore he would not get the defence. So the second part of this section, where the defendant is unable to establish nature and quality, so they, for example, do understand the nature and quality of their actions, then they still have a chance of succeeding with the defence if they can prove at the time of the crime they did not understand that they were doing something wrong. So if the defendant was aware of the nature and quality of his actions, then he must not realise he was doing something wrong. So again, AO2, the problem is here. The people who are not going to be captured by the defence because of this section is your psychotic type defendants. They will understand nature and quality, but what they'll also understand is they are doing something criminally wrong. So this section is still not going to help those type of defendants. So another issue was there's various options that have been discussed in the courts. Legally wrong, so does the defendant have to show that he didn't understand what he was doing was legally wrong, so does not know he's committing a crime? Or does the defendant have to establish that he did not know it was morally wrong? Or is it a combination of both? So again, it's another reason why Parliament need to reform, because these tests have been discussed in different cases. So, very famous case of Windle. In the case of Windle, the defendant killed his wife, who had constantly and persistently threatened to commit suicide over many years. And actually both of them were classified as insane. They have different mental disorders. We both had classified forms of insanity. So his wife had threatened to commit suicide day in, day out for a number of years. So Windle was also suffering from mental illness when he gave his wife over 100 aspirin. So, of course, with 100 aspirin, she did die. When he was arrested by the police, he said, famous quote, "I suppose they will hang me for this." The medical evidence showed that he was suffering from a form of insanity called folie à deux. His words indicated that he knew his actions were legally wrong, and as a result, he lacked a defect of reason. So even though Windle had a disease of the mind, he was deprived of a defence. So think about Windle. Yep, if you'd gone through defect of reason, that would have been there. Disease of the mind, the doctor said yes, he had a disease of the mind. Nature and quality, yes, he understood that he was committing murder and why he was doing it. And also he knew it was a criminal offence. His words, in effect, established exactly that. So he knew that he would be hung for that. So he knew that murder was a crime. So even though you've got a defendant here who's clearly insane and needs treatment, didn't get it because the test is not medical. And that would be same for your psychotic type defendants who I keep mentioning. They'll have the defect, they may very well have the disease of the mind, but they will understand the nature and quality, and they will also know that they are committing a criminal offence. So question, how would Windle be decided if the test had been a morality test? So if you just go back to above on the handout, just note there that the test out of the three options is legally wrong. That's the one the courts have gone with ultimately. So would it have been any different had the test been one of morality? The answer is yes, it would have been decided differently. When you asked the question to Windle, did you know you were doing something legally wrong? The answer was yes, because he said that. He knew it was a crime. But when you ask him whether it was morally wrong, he thought it was morally right to help his wife after her repeated threats of suicide. So he did not think it was morally wrong. So your answer to that would be he would have a successful defence of insanity, -NGRI, not guilty reason insanity, as he did not think it was morally wrong. He knew it was legally wrong, but he did not think it was morally wrong. And that would be a fair result. This is a defendant who clearly needed severe treatment for his insane disorder. Final question, what is the major criticism of this element of McNaughton? Insanity will not be available for the most dangerously ill people. For example, psychotic and psychopathic type defendants. They will understand nature and quality, and they'll always know that they're doing something legally wrong. So the last little section to insanity is the procedural side of matters, which is the impact of a successful plea of the defence. And just a note that this handout is particularly long, but remember the vast majority of the middle part is then transferred straight onto automatism, which makes that a much smaller handout. So just stick with it. Okay, so procedure then, the special verdict. Where insanity succeeds, the defendant will be found not guilty by reason of insanity, which we put in brackets NGRI. Again, that would be perfectly acceptable, just to write it in full and then NGRI thereafter. So this is known as a special verdict. So where insanity succeeds, it's the SV. Before 1991, and this is another huge flaw in the defence, before 1991, this meant that the courts had to impose a mandatory, unrestricted hospitalisation order for every successful plea. So even if it was just theft of a Mars bar or a petty assault, every successful plea meant that you were hospitalised, and that was unrestricted, so that could be for a long length of time. So in short, it's another reason why nobody wants to plead the defence, and that's why it's so rare to see it in the courts. Nobody wants the label, and certainly nobody wants this unrestricted hospitalisation order. If it was, for example, theft of a chocolate bar, you would rather, as a defendant, plead guilty and receive a fine or some other community-based penalty. So before 1991, it was not good. So question, what was the drawback of indefinite hospitalisation? just kind of answered that, but let's just write in there for the record. Most defendants, if not all, would avoid the defence, even if they needed treatment, just to avoid the indefinite nature of being placed in hospital. So that's dangerous, because you've got dangerous people who are pleading guilty, who would then go to prison, their medical condition would not improve, and then they would be released. So insanity was not working. We want to clearly give dangerous people treatment, those that can be treated, to release them back into society. So that wasn't good. And then things changed slightly under the Criminal Procedure, Insanity and Unfitness to Plead Act 1991. This now gives the judge flexibility as to how he deals with the defendant once he has received a successful plea. Now, apart from murder, murder's the same. Murder has to be indefinite hospitalisation. But for any other crime, except murder, the judge has a variety of disposal orders that he can award. We can't call these sentences because, of course, this defendant is found not guilty by reason of insanity, so they're called variety of disposals or disposal orders. So a couple of examples. D could be given a hospital order, and that can be restricted or unrestricted, so they could be sent to hospital for, say, 3 months, 6 months. A supervision order, so the person is given their liberty but they are supervised. Or an absolute discharge, which is where D is just asked to leave court, usually upon the proviso that they don't then reoffend within a number of months or years. However, for murder it's still the same, which is right. It's an indefinite hospitalisation order which must still be brought. The defendant will only be released upon direction of the Home Secretary. And again, that's still flawed, really. Even though that's good for society, that somebody who is insane is given indefinite hospitalisation, what will happen is most people who kill would rather plead guilty to murder. They'll do sometimes as low as an early plea, 10 years, and then get worsened medical conditions and then be released back into society. They'll avoid the treatment. And again, by pleading insanity, they still get the label of insane. So for murder, it's still not great because most defendants will not choose to go with that option. So, final question, how and why was this act, the Criminal Procedure Act 1991, amended by the DVCVA, the Domestic Violence Crime and Victims Act? The problem is with the Criminal Procedure Act and insanity in general, you've got judges imposing treatment but based upon a judicial test, not a medical test. So fair enough if a judge is sending somebody for treatment or hospitalisation if it satisfies the medical test, but it is out of line with human rights if you are imposing treatment when it's not satisfying any kind of medical test. So the DVCVA corrected that, or attempted to correct that. Now, any person that is given hospitalisation must comply with the Mental Health Act. So that has improved one aspect of the defence. So overall, that's the end of the topic. So we've got 3 sections that are really important. Section 1, defect of reason. Section 2, disease of the mind. Section 3, nature and quality, stroke, wrong, the meaning of wrong. Does he understand he's done something criminally wrong? And that's the defence of insanity. Now, the sister defence or brother defence to this is automatism, which is dealing with a lot of the same or similar cases. So it's a much smaller topic because a lot of it we've already covered. So what I would suggest is then you, after you've synthesised this information and gone through a couple of gap charts, then attempt the next and final topic.